following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the advantages of trusts over wills and what happens if you have neither. So let's talk about first what happens if you pass away without a will or a trust. This is called dying intestate. And what will almost certainly happen if you own any significant amount of assets, including just owning your home, is that a probate case will have to be opened in order for your administrator, estate administrator, to distribute the assets to creditors and heirs. A probate case is something we want to avoid because it takes about a year and it can cost up to 5 to 10% of the estate, and it can be stressful for everyone involved. In addition, your administrator will have to buy a bond and submit that to the probate court. So what a bond is basically an insurance policy against them screwing up the administration of the estate. Finally, you won't have any control over how your assets are distributed if you don't have a will or trust, because state statute will determine who your heirs are. For a lot of people, this is fine. You know, if you just want your spouse to get everything, and if your spouse is not living, then your kids, that's an okay outcome because that's what state statute says. So now let's talk about the advantages of having a will over dying intestate without a will. So a common misconception is that a will keep you out of probate. That's not true. Even if you have a will, but if you don't have a trust, your estate will have to go through probate. So all of the bad things about probate we talked about earlier will happen to your estate if you don't have, even if you do have a will, but if you don't have a trust. However, there are some advantages of having a will versus dying without one. One is that you can waive the bond requirement, so your executor won't have to buy a bond and submit it to the probate court. The distribution of your assets will happen according to your wishes. So if you don't want what state statute says your heirs are to be your heirs, if you want to give to charity, or if you're estranged from one of your children, or if you have a friend that you want to get a portion of your estate, you can provide for that in a will. Third, you can name a guardian for your minor children. If you don't have a will, then basically the court will determine who the guardian of your minor children will be. There might be a battle over it, and you don't get that choice, and that's one of the most important things you can do in an estate plan. So that's basically what a will does over dying without a will. Guardian for minor children, control over distribution of your assets, and the waiver of a bond. You can also select who your executor is going to be as opposed to having that chosen by the court. Let's talk about kind of the meat and potatoes here is the advantages of a trust over a will. The big thing is that a trust, if properly drafted and funded, will keep your estate out of probate. So that means that your trustee, who's responsible for administering the trust, won't have to hire an attorney. It's sometimes advisable to do so, but it doesn't cost very much because you don't have a year-long probate case, and they'll be able to administer your estate according to the terms of the trust immediately. However, you'll also have long-term financial control, meaning that the trust can stay in place for years and years and years and years, whereas a will, your wishes are effectuated immediately and that's it. With a trust, that's an entity that can own property after you pass away. The trustee can manage that trust for the benefit of the beneficiaries until they reach the age of 30. Some people do that, or until certain life events happen, or pretty much indefinitely. There's some rules that limit how long a trust can go, but you can actually have some control over how those assets are distributed and managed, and basically, there's a lot of control beyond the grave of how this is really important for parents, how your kids are being taken care of, and you can be as creative as you want with that. Additionally, you can plan for your own disability. So a trust is effective while you are alive. While you're mentally capable, you're both the trustee and the beneficiary, so you don't even notice that your assets are owned by a trust. But you can name a successor trustee to take over for you and manage your assets on your behalf if you become mentally incompetent. And this, along with having powers of attorney, will prevent a guardianship proceeding from being required in order to allow people to manage your medical care, your living situation, and your estate, your assets, your financial management if you become mentally incompetent. This is beneficial for the same reason that avoiding probate is beneficial. It saves everyone a lot of headaches and money and time. To basically have a switch flip when you are judged by a doctor to be mentally incompetent rather than going through a guardianship proceeding in order to give people control of your assets for your benefit. A trust is protected from renunciation. Meaning, a will can be renounced by your spouse, and they can just choose to take a certain portion of your probate estate. But a trust doesn't go through probate. That's not part of your estate. So your spouse can't renounce your trust the way they can renounce your will, and whatever you wish to happen in your trust will. And finally, there's confidentiality in a trust that you don't get from a will. A will has to be filed with the probate court when you pass away, and that's then a matter of public record. A trust is never filed anywhere, so nobody has to know how your assets are being distributed unless it's challenged in a court. So why would you want to have a will in addition to a trust? This is particularly important for people who are parents of minor children. The one thing a will can do better than a trust is name a guardian of minor children. A trust can't do that. So for people who are parents of minor children, I strongly recommend having a will in addition to a trust. The second thing that a will can do is that if for some reason part of your estate does have to go through probate, if you made a mistake in funding your trust, and basically let's say you got a timeshare, didn't realize that was real estate, didn't put it in your trust, and now you've got real estate outside of a trust, which triggers a probate case. Now what happens is everything that's in your trust still passes free and clear of probate immediately without going through the rigmarole of the probate case paying attorneys. But now you've got a big portion of your estate that is going through probate outside of the trust. Well, if you just have a trust and not a will, the trust can't control what happens to that portion of your estate that is going through probate. So what a pour-over will do, in addition to naming a guardian for minor children, it says that if part of my estate is required to go through probate, I want the terms of my trust to control that probate estate. So then whatever wishes you state in your trust for how things are going to be handled are going to be effectuated even if part of your estate passes through probate outside of your trust. So those are the basics of the advantages of a trust over a will. It's not necessarily a one-size-fits-all, so you should speak to an attorney to determine whether a trust is necessary for you. But for anyone with real estate or more than $100,000 of non-real estate assets, I usually recommend a trust, and sometimes if you have minor kids, I'll recommend a will in addition to a trust. So if you have any questions, please leave them in the comments section below this post at learn-about-law.com or on the comments section of our YouTube channel. If you'd like, you can call us for an initial consultation at 630-324-6666. We do offer free consultations in almost every area of law, and we would love it if you subscribe to our YouTube, iTunes, and SoundCloud stations. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.